GREI Club, and welcome to join our Saturday morning meeting. And again, thank you very much, David. We have the honor to have you join us on a Saturday session, and we really appreciate the ongoing support. And you're going to provide us with an updated presentation on where the latest tenant moratorium is going to be, and also share with us a bit on the update on the AB 1482, AB 91, as well as AB 832. Mr. David Bonacassi is a partner with the law firm of Bernard Backley and Bonacassi LLP, and he has practiced law in Fremont since 1987. He obtained his law degree from the Santa Clara University. And Mr. Bonacassi also served as a former Fremont Council member in the City Council in year 2017 to 18. He also spent 10 years on the Fremont Planning Commission and was twice elected as Planning Commission chair. So David was involved in addressing the issue of rent stabilization and reform the rent review ordinance. So David, you have the floor right now. Thank you.
Good morning, Monica, Yun, and good morning, Global Real Estate Investment Club on a Saturday morning. Thank you all for showing up early. We have a lot of updates. It's really time sensitive what's happening with the ongoing pandemic and its impact on moratoriums, both residentially as well as in the commercial arena. So I'm briefly going to go through the history because we've been at this since March of 2020. So you understand the various interplays between state law and local law. On March 16, 2020, Governor Newsom then authorized and renewed local control for commercial moratoriums. So I'll talk maybe in one slide about the commercial moratoriums. That's all done at the local level. He didn't have any statewide law. There's been no legislation passed at the state. Counties and cities initially did have the authority to do local residential moratoriums and commercial moratoriums. But what we're going to be focusing on really is on the residential side from September 1st, 2020, almost a year ago, with some limited exceptions up to the present. The state has stepped in and set statewide rules for how landlords and tenants work through non-payment of rent and evictions and timing efforts in order to enforce rent collection when there's been a non-payment. Next slide, please. So in September 1st, 2020, the legislature passed AB 3088 called the COVID-19 Tenant Relief Act of 2020. So I've underlined the acronym there. I will refer to it as CITRA. And then later enacted SB 91, as Ms. Yun mentioned, and then most recently enacted AB 832. So I'm going to take you through three pieces of legislation. There's a lot of commonality among the three, but there are some important changes. Again, CITRA became law on September 1st, 2020. CITRA, SB 91, and now AB 832 is the state law for residential moratoriums. Santa Clara County did have a residential moratorium, but it did not renew its moratorium until August 25th. It was too late. And so AB 3088 or CITRA superseded it or replaced it. And so there's no more a residential moratorium enacted by Santa Clara County. You have to look at state law. On June 29th, 2021, AB 832 passed, and it was an urgency ordinance, which meant that it took effect right away. And the most important thing for all of us today is AB 832 is today's law, and it extends through October 1st, 2021 in limiting COVID-19 rental debt up to 25% rent for and puts a moratorium on evictions. Don't worry, I'll explain all of this to you. Couple of ground rules. I'm not providing legal advice today. This is informational only. If you want to seek legal advice, call an attorney. You can call me as well in that kind of arena. But today it's focusing more on informational. But there's a lot of information here. Don't be worried. Don't be concerned. I'll take questions after we're done with the presentation. And as Ms. Yun said earlier, I'm happy to give you and will be providing you this PowerPoint so you can read through it. Next slide, please. This is the highlights of Citra, SB 91, and AB 832. None of these laws apply to commercial tenants. It's only residential tenants. And during this presentation, you're going to hear me refer to some terms that the legislature has defined in this legislation. There's going to be the period from March 1st, 2020 through September 30th, 2021, which is called the covered time period. There's in that, it's like a little Venn diagram with little circles inside that. From March 1st, 2020 through August 31st, 2020, we have what's called the protected period. That was really after the onset of COVID-19 when we had major lockdowns at that time, and we did not have a vaccine, of course. September 1st, 2020 through September 30th, 2021, is we call it the transition time period. Again, this was enacted in September of last year and renewed in February and again in July. There was some belief at that time, before Delta and before Gamma, before Lambda, that COVID-19 would not be an ongoing issue. So they've said, at least at this time, this transition period from moratoriums back to traditional landlord-tenant law. And there's a little bit of a surprise that hasn't been discussed much yet because we're focused on trying to get through the moratorium. But even after the moratorium lifts, the legislature in AB 832 already enacted a period of time after the moratorium lift called the COVID-19 recovery period rental debt, all the way to March 31st, 2022. So even if everything optimistically sunsets on September 30th or October 1st, and the legislature takes no further action, there's going to still be some aspects of AB 832 that's going to limit the ability of landlords to evict tenants, and they're going to have to still undergo certain steps to show that they've done all that they can do before they can enforce a 3-day notice to pay rent or quit and go to court at that point. So we'll discuss that. One of the key features of the Citra SB 91 AB 832 triumvirate of legislation is something called the Declaration of COVID-19 Financial Distress. If you get that from a tenant and it's only under penalty of perjury, it sets into motion a whole series of rules and restrictions on the landlord on the ability to recover rent and how, at the end of the day, the landlord can collect on that rent. All the tenant needs to show, again, by signing it, no supporting documentation is required or can be compelled, is that they've lost income due to COVID-19, or there's been some substantial increase in COVID-19 related expenses due to healthcare costs or caring for a child or an elder or somebody else in the family because of COVID-19. There is also something called a landlord-tenant informational notice. And then there's a 15 that was supposed to advise tenants who have not paid on time at any point from March 2020 up to the present of the current law in place of now AB 832. There's also, instead of a 3-day notice to pay rent or quit, you now have to do a 15 business day notice to evict in order to be able to preserve or at least take the first step in being able to go to court for non-payment. From the period of time of September 1st, 2020 through June 30th, 2021, landlords cannot evict tenants who submit a COVID-19 declaration and then only have to pay 25% of their rent. If you look at number 9, it says AB 832 requires the landlord to serve a new informational notice. We've already passed the July 31st date, and I'll talk about it later as to what I think that should mean. But really what AB 832 has done is extended this 25% rule all the way up to September 30th, 2021. So let me give you an example. Let's say a tenant hasn't paid in July, doesn't pay in August, doesn't pay in September any rent on September 1st. Let's say it has rent of $10,000 per month rent. I know that's high, but I'm just doing the numbers here. Let's say it's $10,000. They owe $30,000 at the end of September 30th. As long as they pay 25% of that rent on September 30th, you cannot, as a landlord on October 1st, say that they are behind in rent for purposes of recovering possession. Okay. Typically, non-payment of rent in California before the pandemic was an automatic right to go forward and recover possession, not during the pandemic, as long as that tenant pays at least 25% of the rent at the end of the covered period, at the end of, in this case, September 30th. So I can go back all the way to March 1st, 2020, and there is a period of time from March 1st, 2020 up to August 31st, 2020. During that covered period of time, if they pay zero rent, you can never use that failure to pay rent during that that protected period as a basis for evicting a tenant. From September 1st, 2020 up to September 31st, 2021, almost 13 months. As long as they pay 25% of all the rent that was due between those timeframes, you cannot use their failure to pay the other 75% as a basis for filing an unlawful detainer action to recover possession. I think, Carl, do we have some forms here? Next slide, next area. Okay. So what we do is I have here, and then I have here, there's going to be a whole series of forms. You're going to get the forms for free, and you can read them at your leisure. I have here the new 15-day pay or quit notice that you have to give, and that's for this most recent time period. And this is the form that you're required to provide your tenant if they're behind schedule. Now, behind on rent, the language is not made up. You can't deviate from it. It has to be the statutory language. You want to show some of the other forms that I have in here? This is the same one, I believe. I could be completely wrong, but I believe this is the one that's in Chinese. And again, this is actually an important, let's stop for a minute. Let me make a point here. My strong recommendation, I'm not giving legal advice today, but if you were to take what I'm about to say to heart, if you are Chinese yourself and speak in Mandarin, and you have tenants for whatever reason who speak in Mandarin, my strong recommendation would be to speak only in English. The reason is, under California law, if you primarily negotiate the lease terms, lease extensions, and if somebody's behind in rent, text in Chinese or email in Chinese or a call in Chinese, then you're required to provide only Chinese forms in that language. That's also true for Korean, Spanish, Tagalog, and I believe there's another language if you're speaking those languages in that native tongue with some other native speaker. And so here, if you look housingiskey.com at the bottom at www.housingiskey.com, I'm going to show you the website later. There are actually forms already available for free in Chinese, and so you should do that in Chinese if you've been negotiating primarily in Chinese. Why? Not just to be nice and try to communicate, but if you fail to do so and even do the right notice in English, the tenant who speaks Chinese can say, this is not valid because you did not send it to me in my language, and you know, because of how we negotiated, that that's my primary language. And so whatever process you start trying to do, this is the new 3-day notice to pay rent or quit. It's 15 days. You exclude Saturdays, Sundays, holidays, and counting the 15 business days to get to the 15th day. If you don't get rent, then later I'll tell you when you can start going to court to begin the unlawful detainer proceeding. They could set aside the whole unlawful detainer because you did not use the forms in the language that you had negotiated the lease agreement. Next slide, please. Next form, sorry. This is again the tenant declaration of COVID-19 related financial distress. This is a form that I've gotten from, I think, the California Association of Realtors. If you notice, all it is date, the tenant sign here under penalty of perjury, and that's it. And it's one or more of the following. They don't even have to check which one it is. And if you get that, then that invokes all the protections that the tenant is entitled to under currently AB 832. Next form. That's actually, Carl, this was the one I was going to talk about later. So we'll go back to that form, okay? Next form, please. This is the notice that should have been in effect and sent to a tenant who was behind in rent anytime between July 1st and July 31st, 2021. Well, this is August 7th. What happens if you haven't given a notice for a tenant that was behind rent when you want to give them a 15-day notice to pay rent or quit? My suggestion is give it to them. There's been no case law on it. Even if it's late and the 15-day notice to pay rent or quit says a lot of the same things, but you've checked it off and maybe the court will say substantial compliance. But this is one of my criticisms of these laws, is that they're enacted quickly, they go into effect within days of passage, and there's really very little ability for the larger landlord community or the tenant community, for that matter, to know the obligations and the benefits of the new legislation. So there can be these what I call an English term gotcha. Either you have something that if you fail to do could be considered critical. And so maybe some judge in a couple of months will say, well, you never sent the notice out, or you sent it out only when you sent out the 15-day notice after July 31st. You can't invoke any of these procedures. You have to start all over. The tenant gets another opportunity of continuing to live in the property. Next form. There we go. Okay. Keep going. I think maybe these are all the forms. I thought I had some more forms in Chinese too, so that's okay. We'll get them out there. Next, this is the slides again. As Monica said, Ms. Young said, I was going to also talk about AB 1482. That could be its own seminar. It was enacted and took effect, or it was enacted in 2019, but it took effect on January 1st, 2020. I remember clearly having an in-person seminar given to the Chinese American Real Estate Association and its affiliates at Metro Crossing in Fremont in February of 2020. And I thought, well, gee, we're going to have to spend the whole year educating people about this new law because there's all these permutations. And little did I know, or anybody in that room knew that less than a month later, we'd be in the throes of a pandemic with completely new legislation that I'm talking about today. So AB 1482 is important for this reason. The AB 832 and Citra and SB 91 have modified it and expanded it. AB 1482 created a statewide protection for rent caps and just cause evictions. Rent caps meaning that at no time within a 12-month period can the landlord increase rent for a residential tenant who qualifies more than 5% plus the CPI for that area, but it cannot exceed in any event more than 10%. So it's either the lesser of 10% or less 5% plus the CPI. So we're having some inflationary pressures that may push up past the 10%, but in 2020, we were looking at it initially in Alameda County, at least, the rent increase could have been no more than 9.1%, which is 5% plus 4.1% CPI. Just cause evictions mean that again, if you have a tenant who qualifies for this protection, you cannot simply send out a 30-day notice without any reasons for somebody that's lived month to month for less than a year, or just 60-day notice for somebody that's lived more than 12 months like we have historically. You're going to have to follow these, you're going to have to come within one of the cause bases for evictions, and it has to be just cause. It can't be made up. It has to follow the statutory criteria. They importantly at the time exempted single family homes and duplexes where you lived in one of the duplexes, or if your property that you happen to have was less than 15 years old from the time that it first went on the market and people could live in there. So if you were a mom and pop and had a second home and you're renting it out, you know, your AB 1482 would not apply to your tenant, and you could still do the 60-day notice without any reason for somebody that lived there for more than a year. But even then, and I should add that, if you go back, Carl, to the form that I had called the Just Cause Addendum, let me show that to them. Okay, this, the next one, rent cap and Just Cause Addendum. If, and it's most importantly, if you are somebody that would otherwise be exempt, you would want to have this form added to your lease and have the tenants acknowledge it. Because if you see in the box in the middle, I don't have a little pointer, but it says notice of exemption and checkbox. You need to have that provided even as a mom and pop single family homeowner to show that you're not subject to AB 1482 and your tenant isn't either. And if you don't check that box, then it does apply to you. So it's another gotcha. The legislature says that not only if you're single family homeowner or got property less than 15 years old or whatever the exemption is, you have to check that box in order to get out of the restrictions and have that Just Cause Addendum. So look at your portfolios. My recommendation across the board is if you haven't done this yet, you need to have this with all your new leases as an addendum, or have your tenants sign off right now and acknowledge this. But let's go back to the slide. There's an exception to the exception. Under SB 91 and AB 32, AB 1482 protections now applies even to single family homeowners that rent, that are mom and pop, that don't operate through a corporation or a limited liability company where there's a corporate member. And so for the period of time up through September 30th, if you thought about, well, AB 1482 doesn't apply to me, and even if you had the Just Cause Addendum signed by your tenant, as long as this moratorium exists through September 30th, you have to go through the Just Cause eviction process itself and follow the rules, okay? It also has changed for everybody across the board, whether you were subject to AB 1482 or not. There is a Just Cause exemption or instance where if you do a substantial remodel, you can move a tenant out in order to be able to remodel it, then remarket it, and there's vacancy decontrol, which means you can then market at current fair market, even if it was much higher than the rent that you had from the prior tenant. But during the pandemic, they're saying we're not going to allow landlords to get out of their leases with tenants by saying, oh, I'm going to do a substantial remodel. We're only going to limit those to instances in which there's an imminent health concern and you have a governmental citation saying you need to make this remodel. So it basically eliminates this basis through the pandemic. And again, AB 832 extends AB 1482 protections until October 1st, 2021. Next slide, please. More highlights. This is something that's come in. It wasn't true with Citra through February of last year. It became true under SB 91 and 832 after the stimulus package was passed early this year. Suddenly there was rental assistance programs, okay? And now under AB 832, if you have a qualifying tenant, the tenant can get up to 100% of past rent, past utilities, and some future rents and utilities covered up through March 31st, 2022 for rent. So if you have a tenant that's been behind since March 2020, this is the opportunity for them to get assistance to be made whole, okay? And to make you whole for the rent that you haven't gotten from the tenant. But there's a couple of real kickers here that really limit its scope. The tenant has to have income that is at or below 80% area median income. That's the threshold. And so I'll talk about that later. If you have a high income tenant above 80%, they won't get the governmental assistance. And even if they're at 80 or below percent, some of the programs I'll talk about later restrict further to lower levels of, deeper levels of affordability or income impact down to 50% AMI. So we have a high earning area. We have people that if they're working, most people here in the Bay Area, they're in the Bay Area because they have higher income. That many of your tenants that you may be renting to will not fall into that category. And so they won't be eligible for this income. There are new tenant protections I'll talk about in a later slide under AB 832. They continue some of the protections that were first enacted under SB 91 back in February. AB 832 prevents the filing of a non-COVID-19 no-fault unlawful detainer until October 1st. So one of the areas that I've had clients coming in is that they're tired with the rental market issue, all the headaches. So and it's a hot market for selling houses. So the combination is a perfect storm for a lot of mom and pop landlords to say, I give up, I'm behind on my mortgage, I want out. And so if you say that you're removing the property, if you're removing the property from the rental market, in other words, to sell it, that is a just cause eviction under AB 1482 that you'd have to put in there. If the tenants have been there for more than 60 days, you give a 60-day notice. Well, let's say you did that in June. The 60 days would end, if June 1st, the 60 days would end at the end of August. Can you go in on September 1st to go with your unlawful detainer if they don't leave? No, you have to wait until October 1st. For those that have rental debt, you cannot go in until November 1st, 2021, a month later. So they're staggering out the times in which you can go back into court, and the no fault non-rental issues will get first in line beginning in October. You can at least begin the process of filing the unlawful detainer, and then they're going to delay or stagger until November 1st as the earliest date where you can try to collect unpaid rent for the previous months. But this is going to be extremely important for you. Under AB 832, the landlord must show efforts to collect rental assistance with tenant. The landlord has to cooperate with the tenant. And there's going to be a little mandatory cover sheet where the landlord has to fill that out. And if the landlord cannot truthfully under penalty of perjury indicate that they made any efforts at all, they're not going to get the summons issued right away. Well, what's the summons? When you file a lawsuit, you can't just go to court and file it. You need to have the clerk issue what's called a summons. That empowers you then to take the summons and the complaint and serve the tenant with the lawsuit. If you don't get a summons, you can't serve the lawsuit. If you don't get a summons, you can't begin the process. So the summons could be delayed up to 20 days or more until you show, and the clerk's going to look at it. So, well, what efforts have you made? You haven't filled this out. And if the tenant shows that you made no efforts at all, that's going to be a basis for defeating it. This provides an interesting problem for landlords. What if you think your tenant is, working at Google and has a high income and is above 80% AMI? That Google employee doesn't pay rent, blows you off. Well, you think, well, in my mind, he doesn't qualify for financial assistance. I'm not going to apply. I would say that the law doesn't differentiate. Even if you have a subjective belief your tenant is above 80 AMI, I think you need to still go through the efforts to say with the tenant cannot apply and the tenant made an effort, or there's some showing that the tenant really is above 80% AMI. How you prove that, whatever, you should at least go through this exercise of trying to prove that in some matter, or else the court's going to say that you didn't exhaust efforts to collect. Doesn't mean you have to collect the financial assistance. It means that you and your tenant cooperated and making every effort to try to collect it. Next slide, please. There is important, again, tenant debt collection issues depending upon whether the tenant invokes COVID-19 with that declaration that I showed you earlier, which they sign, or whether they don't. And there's a distinction between whether they invoke COVID-19 protection under financial distress and the ability to claim financial assistance. Those don't necessarily overlap. They overlap, but they're not necessarily exactly the same. So for COVID-19 rental debt, for tenants at or below 80% of the AMI who timely submit COVID-19 declarations, they're eligible to receive up to 100% of the past rent from governmental rental assistance for the protected period and for the transition period and for the COVID-19 recovery period between October 1st, 2021 and March 31st, 2022. So let me just look at Part C, just so that you're looking ahead. Again, assuming nothing gets changed. Let's say you've had a good tenant or you had a new tenant come in and it's now November 1st and they haven't paid rent. You are obligated at that point still to seek rental assistance for that new tenant or that old tenant that becomes behind even after October 1st. So there's going to be this continuing process at least until March of next year, in which you're supposed to go through and try to invoke COVID-19 and financial assistance. What happens, remember earlier I said that a tenant that only pays 25% by the end of September is not subject to a unlawful detainer action for recovery for non-payment of rent. Again, what happens to the other 75% that they don't pay by September 30th? You can never collect that in an unlawful detainer action. You have to then go to small claims court. So small claims historically for individuals that has been capped at $5,000. And you say, well, look, I have rent owed by this tenant that's 25, 30, 35,000. I can't go to small claims. The legislature has made an exception for unlawful detainer actions. I'm sorry, for rental payment actions where you can collect up to whatever the rent is due, whether it's 25, 30, 40,000, whatever, you have to go to small claims. And you cannot go in that direction until November 1st. So again, the courts are going to be blocking you to try to recover it. But if you have that ideal tenant that failed to pay, not ideal for you, but the tenant that minimally did what they were required to do under AB 832 and paid 25% to protect themselves from an eviction process for not paying the other 75%, is that, again, you can't evict them for the failure to pay anything more than 25%, and you could collect the other 75% in small claims. I think this is important in numbers 4 and 5. You can have a tenant who for whatever reason never gave you a COVID-19 declaration, but they may be below 80% AMI. You're still supposed to go through the effort of getting the rental assistance. And you're going to think, well, gee, they didn't play by the rules under AB 832. They never gave me a declaration that they had hardship. But the rules in terms of going through an eviction process don't differentiate whether they gave you a C-19 declaration or not. You're supposed to still show that you went through the effort to get rental assistance. There's one category of tenants that are like the traditional tenant before any of the pandemic moratorium rental restrictions. Your tenant earns above 80% area median income and who never declared COVID-19 financial hardship, no rental protection whatsoever. So you go in and you still would have to give the 15-day notice if it's before September 30th, because that's when they can still give you the declaration. But then you go in and you can go to court and try to collect 100% of the back rent owed. But with everything here, there's still, whereas if there is an apportionment of rights and obligations, the rights of the tenants in the pandemic here are greater than the rights of a landlord. There's one policy reason for this that's overriding. It's not just simply because the legislature has responded to special interests in one way or the other. There's that going on. But I can tell you that with SB 91 and Citra, that legislation was crafted with the support of the California Apartment Association. So you did have stakeholders on both landlord and tenant side that crafted this compromise legislation. It is true, however, that when the protections were extended through September 30th, 2021, the California Apartment Association dropped out and said, we're done with the moratoriums. We want to go back to the old rules. But keep in mind that that was in the end of June when they enacted AB 832, before the onset and the dominance of Delta as a new variant for COVID. But there's one other hurdle for a landlord. You could have a tenant who is above 80% AMI who can still declare COVID-19 financial hardship. It's not restricted to where you are along the income scale. You just have to do that under penalty of perjury. And you can have that tenant, or that tenant can in fact file that financial hardship declaration during the court proceedings. And if there's a motion on that and the court agrees, then your eviction process is halted and you have to go back to square one. So there are a lot of off-ramps here where a landlord is not going to be able to recover possession of his or her unit based on non-payment of rent based on AB 832. Next slide, please. I've mentioned this before, but there is a new documentation to show by the landlord in filing an unlawful retainer action. A landlord must show good faith effort at investigating the availability of rent relief, sought governmental or even third-party assistance for residents. And in Santa Clara County, I believe there's a nonprofit foundation that's providing some rental assistance. Again, limited, but you have to show that you went through the checklist with the tenant. Cooperate with the tenant. Applies to both non-payment of COVID-19 rental debt in the protected period and during the transitional time period, and in small claims or non-payment. So even if you go through the 25%, you're not going for an eviction because the tenant has minimally paid the 25% from September 1st, 2020 through September 31st, 2021. And you're trying to go after the other 75% in small claims. It's not a free ride for you as a landlord. You say, well, they didn't pay the 75%. I'm just going to go and file my small claims for that. You still have to show, even in the small claims action, that you try to get governmental assistance so that you didn't try to simply burden the tenant with the debt when there may have been rental assistance available. And as I mentioned before, even if the tenant fails to submit a COVID-19 declaration that I showed you earlier, in response to a 15-day notice to pay rent or quit, tenant can still raise the right to COVID-19 relief in an answer to the unlawful detainer action. Next slide. There are new tenant protections going forward. There are two classes of tenants. Tenants who've declared financial distress under COVID-19 by giving you the declaration, and all residential tenants, whether they've given you the declaration of financial distress or not. The declaration, for those that are financially distressed and have given you the declaration to show that, you can never collect late fees, whether unpaid, before or after the declaration from those tenants. Nor can you increase or charge new fees for services. So a typical example may be in an apartment complex, or even in a fourplex. You may have rental agreements, and then you may charge for parking. Well, you can't then suddenly say, okay, I'm not increasing rent right now, but I'm going to increase the charges I impose for parking. If they've given you a declaration of financial distress, you cannot impose those increases. The other thing too, here I didn't mention this, but this is one of the other aspects of AB 1482 applying even to mom and pop owners of single family residences. In theory, unless there's a rent freeze in place, San Jose had one, I don't believe it's still in place, you can increase rent during the pandemic period, even for theoretically for tenants who are suffering financial distress. Economically, from an economic perspective, I wouldn't do that. If they can't make rent at the current rates, leave well enough alone. And usually in the question answer period, I get these questions and I try to be practical about it. But there is a cap now for you, even as a single family homeowner that has the property in your trust, or you're as a husband and wife, or just a single owner that's not a corporation. You're restricted to the caps I mentioned under AB 1482, which is no more than 5% plus CPI or 10%, whichever is less. For all tenants, whether they're receiving COVID-19 or declared COVID-19 related financial distress, you cannot apply the security deposit without the permission of the tenant. Even if the rental agreement says that you have that authorization, and most do, you cannot do so without tenant permission under the law, as long as the AB, and I said SB 91 tenant protections. This was a slide that I prepared for SB 91. I should have modified it to say AB, as continued by AB 832. So all of these are still in place. Rent payment must be applied to future rent, not past rent due. This is particularly important for the tenant, because I had questions early on before this SB 91 was in effect, and I answered the correct. I anticipated what the legislature ended up doing, even though it was not yet the law until SB 91 passed in February, which is, if you recall, as I mentioned, during the protected period for tenants that didn't pay between March of 2020 and August 31st of 2020, you could never use that non-payment of rent as a basis for evicting them. You can collect it in small claims, less any efforts to collect financial assistance from the government, but you can never use it to evict them. So you're thinking, gee, I don't want to go to small claims, and I want to get a rent payment I get in, let's say, this year, and they're trying to catch up. I'm going to keep applying it to that period of time last year from March through August. And so I'm only dealing with the 75% rule after September 1st. And at least I get 25% in the unlawful detainer action. You cannot do that. Legislature saw that issue rising and saying, you got to apply it to future rent, not past rent due. In other words, current rent, or future rent is a misnomer, but if you pay rent on the first day, it's for the 1st to the 30th of that month, or the 31st. So you cannot go back in time and try to make up for past arrearages. You cannot use past COVID-19 rent problems as a negative screening for new tenants. Cannot assign rental debt to collection agency until July 1st, 21, and permanently you can never assign rental debt for tenants who qualify for rental assistance. So you've got a small claims action you want to bring. You want to get maybe 30 cents on the dollar and have a collection agency do it. You could start that process now for a high income tenant that didn't qualify, but you can never do that for a tenant who has qualified for rental assistance. So you can't, as a landlord, take rental assistance on the one hand and then go out to a collection agency to try to be made whole for tenants who do get rental assistance. Next slide, please. Again, state rental assistance program, I've talked a lot about it. This goes through some of the criteria. 80% or less of area income, one person in household, risk of homelessness or housing instability. This is where it really gets practically a real problem. And when we talked about the federal eviction, and I'll get to that at the very end, why it doesn't apply in California, a lot of tenants were saying, rightly so in my view, why should we be evicted when we're eligible for financial assistance, but our governor hasn't given out the assistance? Our state is slow. In South Carolina, for example, even though this money has been available for 5 or 6 months, South Carolina had only doled out money to 9 landlords in the entire state. So California is also having trouble getting the money out. And even beyond that, there is some real restrictions. They're trying to give money first for those that are less than 50% AMI. So if you have somebody at 51% AMI that might be eligible for rental assistance, the money may not be there yet. The second round is for those that are disproportionately impacted by COVID-19. That's LA. That's not up here. We've not been disproportionately impacted by COVID-19. We've been following the mask ordinances, the social distancing. So if there's any other monies, it's not going here first. And then finally, up to 80%. Okay, so it's 3 priorities. It's kind of vague, but the fact is, even if the money's there, it may be coming out, dribbling out in very limited ways for you and the tenant. Next slide. Again, the applications for state funds opened up back in March. I've talked about 80, 32, 100% of past rent. Tenant comply without landlord cooperation. But if landlord refuses to apply or doesn't help the tenant, then even if the tenant gets the rental assistance, landlord is only limited to recovering 25% of the rent due. It's a real penalty on landlords that refuse to cooperate and try to get rental assistance. Landlords should never refuse receiving rent from rental assistance. I would hate to think a landlord says, well, I want it from your checkbook only, but I'm not going to take government stimulus money to pay off the rent. I don't believe in that philosophically. That may be violate fair housing laws and income discrimination. Again, judges have the power and reduce rent if the tenant met eligibility requirements and bar the landlord from some of the past rent. If the tenant can say, hey, look, I applied and I was and still waiting for X amount of dollars, the judge in his discretion or her discretion may just reduce your recovery of small claims, again, if you didn't do anything. Next slide. Here is where you're going to want to keep these websites close to home and start, utilizing them for tenants that are past due. This is the statewide rent relief program, and it also explains eviction protection guidelines and resources. And again, this is important if you're a homeowner or landlord or a tenant. There is a little section there for homeowners on trying to work with banks on trying to defer mortgage payments. There's legislation in place if it's federally backed, but like Sallie Mae and Freddie Mac, but only about 25 to 30% of all loans in California are federally backed. That's more loans back east are backed by the federal government. They are in California for whatever reason. But then they have helpful hints of just dealing with your bank directly if it's not backed by the federal government and working with them on deferring loans. You can find all of that at www.housing.ca.gov, and it pops up with Housing is Key. It is a very busy website. I don't particularly like the layout. If you had somebody that knows how to design websites, I think they could do a much better job, but it is chock full of information. There's even some interactive apps on how these eviction guidelines work, so you can augment what you hear today by reinforcing what you're learning. And then they have forms for you and for the tenant. Next slide, please. Again, my suggestion is if you're a member of the California Apartment Association, go through your affiliated chapter, or if you're a realtor, California Association of Realtors have forms. Again, these are the languages that you would have to provide if you speak primarily in other languages, in Chinese, Korean, Spanish, and Tagalog. They have those forms available in those languages free. And Vietnamese, that was the one I also forgot. Housing, and then I'm giving you the link there, but if you go to Housing is Key, housing.ca.gov, you'll find the form section. In Fremont, if you have tenants in Fremont, the city itself administers its own rent relief assistance program, but it limits it to those that are 50% or below, and there's only 7.1 million, which sounds like a lot, but we have a huge number of tenants in Fremont, and so maybe it's more than enough for the very few that qualify for 50% or below, so that the setting of the threshold is so low that maybe the money will stretch far enough. And then I've given you the website in Fremont to look at that program and how to apply for it. Santa Clara County Again, it goes through a very short explanation of the residential and commercial moratoriums. And here's the website. Again, I would just go to sec.gov.org and then go for find it if this link doesn't work. But that's the link that pops up when you go to the actual page. Next page, please. Watch for future developments. June 29th, 2021, the governor issued a new executive order extending the right of local jurisdictions to enact or renew commercial moratoriums through September 30th, 2021. The one in Santa Clara County expires on August 18th. And I checked the website yesterday and it still says August 18th. So it may end next week or a little bit thereafter, the following week. But you know, the Board of Supervisors might get a little bit of pressure to postpone it at least through September 30th to follow the maximum authority it has under state law. And if the commercial tenant is a small business as defined in the ordinance, then they get to pay and defer their rent for up to 6 months for half of it and 12 months after the moratorium is lifted. So if the moratorium is lifted on August 18th, they have 6 months to pay 50% of the past rent that was due and 12 months to pay the remaining 50%. City of Fremont has a commercial moratorium in place. It will extend at least through September 30th until the law, unless the governor extends the authority of the moratorium to remain in place. But it tiers off the deferral to lifting the local emergency, declaring emergency due to COVID-19. So if you were still in a pandemic situation and the emergency is not lifted until February or March of next year, then at that point, there's a repayment of a 90-day and 100-day period for paying off the commercial rent. So look for future developments. Does the Santa Clara County Board of Supervisors extend the commercial moratorium? Does the governor extend the executive order past 9/30 for commercial moratoriums? Does the legislature extend residential eviction moratoriums past 9/30? I'm going to give a prediction. I think it's going to. So I want you to get in that mindset that I think it's going to. Why? Because during the month of September, we're going to see, the epidemiologists predict, we're going to see a huge spike in hospitalizations, particularly among the unvaccinated due to the Delta. And now emerging slowly is potentially an even more dangerous variant called Lambda. So in the UK, where there's a high amount of vaccination, that are a little bit higher than they are here, it was a 4 to 5 week period of real hell. And then it tapered off quickly, even among the unvaccinated. Somewhat of a mystery as to why that happened, how they reached herd immunity so quickly, even among the unvaccinated. We're not quite as caught up as the UK, but politics is in the moment. And so even if in October we begin seeing tapering off of hospitalizations due to the Delta, I think the fact that the federal government's already extended its moratorium to October 3rd will create some pressure within the legislature, extended at least to the end of the year. This is my crystal ball. I could be completely wrong, but if that's the case, then look for all the dates that I talked about ending in March, extended to May or June of next year in terms of the post transition period, and all of the AB 832 protections for tenants, including AB 1482 applying to small mom and pop owners of single family homes, all remaining in place. What is the effect of the new Center for Disease Control target residential moratorium have in California? The short answer is nothing, at least until September 30th, because we have our own local moratorium in place, and the CDC recognizes if you have a moratorium in your own state or locally in place, that's the rule that applies. Will Congress act before 9/30? I doubt it. And this is a very interesting constitutional issue. The Biden administration acknowledged what they're doing itself may be unconstitutional, even if it's targeted without congressional authorization. So there may be a court challenge to disable this nationwide moratorium. But if for some reason the federal moratorium is extended and they believe they have authority to do it, or do get congressional authorization, that will almost certainly guarantee that the state of California will extend its moratorium. And we have a situation right now, kind of an interesting, almost like a law school problem. What happens on October 1st, October 2nd, and October 3rd? There may be 3 days that the moratorium is in place that the state law sunsets. Unlikely, but it could happen. My suggestion then is, if you're going to do your 15-day notice to pay, rent, or quit, you can't really do anything until November 1st anyway, so it probably has no impact here. But I wouldn't begin, and you can't start filing an unlawful detainer complaint in October. So it really is kind of going to be a hypothetical, but you're hearing a lot of what's happening at the federal level, including some California congresspersons that have been very active in it. It's going to just have some backward effect here in California of really elevating this issue. Particularly, we have continuing Delta community spread among the unvaccinated. And it's really bad now in LA. They're looking at more restrictive measures again. So I do think the state legislature is going to continue the moratorium. So now I think if you just give me about 5 seconds to take a drink of water, I'm going to be ready for questions.
This is very, very informative. I really appreciate the time and effort to put everything together. So we now encourage our audience to type in the questions in the chat box, so David can help to address. Well, I do have a question to start with, David, when you are ready.
Yes.
Okay. So we've been working on some transactions. In fact, like my buyers, I think, also have enrolled on this event. And so we closing on a fourplex, and one of the tenants have not been paying rent during the pandemic time. And then we try to ask the manager, on the status. So the property manager is trying, I think, applying for the outstanding rent, and she has made it very clear that whatever that was owed during the pandemic time before the close will go back to the previous owner. So when my client's closing on the property in a few weeks, what do you think would be the way that would best handle, this particular situation? What particular form that he needs to find, or whether there might be a chance that can we kind of like say invite the tenants out and kind of get the unit back for remodeling or something?
Well, this is all a timing issue. If you asked me before you tried to close, what I would say is don't even try to close until after October 1st if you think the tenant's not leaving. But I would have given a 60-day notice under AB 1482 with just cause eviction based solely on removing. Well, are you removing the property from the rental market, or are you going to just, is the new owner going to continue to rent? What's the status after the close? It's a fourplex, so I take it's going to continue to be a rental unit. Is that the status?
Yeah, of course.
Yeah.
Yeah. So like say all the other 3 units, they have been paying rent. Only 1 unit have not been able to catch up with the rent because of the pandemic. But then because we have a contractual agreement that we cannot delay on closing because the seller conducting a 1031 exchange. So we have to close on time.
Right. Well, if the buyer is fully, there's actually, this gets into 2 areas of disclosure, and this is a separate webinar. Of course, you have to mark, and it's a tenant occupied unit. You don't have to remove the tenants as a contingency of the sales. Sometimes you do in the selling of a home for somebody to move in to occupy it as their primary residence. So you have a situation here where if they've not paid rent, I would simply disclose to the buyer the situation and send out the 15-day notice to pay, rent, or quit, get the process at least going, and see if the tenant declares COVID-19 for relief at that point, And whether they do or not, then you know that you can collect no more than 25% of the rent before September 30th, which may be a post-closing obligation that the buyer takes on. And then in the meantime, try to work cooperatively with the tenant in trying to get as much governmental assistance as possible, so that so that the tenant is not that far behind rent at the time closing happens or soon thereafter, if the tenant is at or below 80% of AMI. So those are all, if you're going to have the closing, you can't continue the closing or make it contingent upon having this renter evicted. These are all the things I would start doing, is make sure that you start the process in place, and then the buyer will have to take on the laboring or maybe assign to you the obligation as the seller, your client as the seller, to remove the tenant after November 1st.
Well, we actually closing like within August. So
yeah,
like I said, there's a timeline the seller have to, but then when can we actually submit that 15 days pay or evict or leave?
You can start the process. You can start the process now and see how the tenant responds to it.
Yeah, so it's legal to submit that even before like end of September, huh?
Oh, absolutely. In theory, and this is thank you for asking it that way, because we're so far advanced in the process right now that we're now edging up to August and September, where there's only one more month of the current law. When SB 91 went into effect, or even when Citra went back into effect, in theory, you could have sent out a 15-day notice to pay rent or quit back in September of 2020. But there was no way to enforce the quit. So you could send the 15-day notice to pay rent or quit now, and maybe the tenant leaves. Maybe the tenant says, okay, I'm never going to catch up. They have the option of quitting. That's in terms of facilitating the sale and vacancy to control and being able to get a new tenant in there at current market rates that's creditworthy. That may be the best solution, but you certainly won't have any of that happen unless you start the 15-day notice to pay rent or quit. And it is timely. I assume you didn't give the informational notice to that tenant in July. Every landlord should have, under this law, provide the informational notice, provide the 15-day notice to pay rent or quit, and see what happens.
I see. Yeah, definitely. I think it's very good suggestions, and I'm surely that my clients are listening, so they would have a way to prepare to do it when the property is closed. So right now, for your advice to clients' cases, and it would be pretty much like, say, is on a case-by-case basis in terms of the people's back rent, and then what is the success rate that people have been able to apply for the rent relief? Because we always hear on the radio and they say a lot of funds available, but not enough landlords to apply. Is it kind of too stringent, or what's happening? Maybe you can share some of your insight.
My insight is more anecdotal. I don't have anything that's authoritative on this, but I would think in Fremont, because it's local control and there are staff dedicated to the issuance of funding, if a tenant qualifies, they've been getting money out the door, but the problem again there is the threshold is only at or below 50% of AMI. In Santa Clara County, there are these forms, and at least with the state website I gave you and the County of Santa Clara website and the Fremont website, the forms are accessible. The processing, though, is still very much delayed, and it's incremental, and it's not enough. And so you have this disconnect between legislation that holds out a carrot to landlords and tenants of saying we can have financial assistance to make tenants pay up to 100% of the debt owed and even into the future. But the financial assistance doesn't match the promise of the legislation. So there's going to be a lot of frustrated landlords and distressed tenants where even if financial assistance is received, it's not 100%. And the tenant, it's not a happy situation for a tenant who still may not have a job or maybe looking for work, that is still going to be structurally short in rent month to month. They may not be evicted now, And the landlord may have more than the 25% because he's gotten the financial assistance for a COVID-19 tenant, but can't evict him and goes to small claims. And so you have this prospect of your landlord suing your tenant while the tenant remains there. It's a highly stressful situation. Maybe there's going to be another, I think, again, this is about politics, but I think if the 50 Senate Democrats get together on a reconciliation package that may happen in the summer, it may very well include more financial assistance, and we may get closer to making the landlords and tenants whole. So we should wait for that. But right now, it's a very frustrating experience for everyone concerned.
Yeah, I see. So I have some clients who have been owning multiple units, say like apartment buildings, and they have formed their own property management company to manage the properties. So during this pandemic time, with so many units, there would be a portion that are not paying rent. So as a property management, of course, they would like to get the rental relief, but then can they also apply for PPP and kind of like to offset some of the expenses like staffing or other costs that they might have to carry?
I'm going to just simply say, I don't think so. I don't know. Because again, you're dealing with the rental market as opposed to the PPP funding, which is really intended for, like retail businesses that serve consumers or other traditional businesses. I think the PPP funding has dried up, so it's a theoretical or academic question. If they haven't applied for it now, I don't think there's any more PPP funding available. So
I see. Well, I do have a couple of questions that are in the chat box now. Say about the 15-day notice in the situation that I have asked, if the old owner just sent out a 15-day notice already, then upon closing, the new owner will need to file another 15-day notice or just inherit the old notice?
No, the new owner is the successor in interest to the property, so it will step into the shoes of the seller and be able to proceed with that eviction as the owner of the property.
I see. Okay, so I hope that answered the question of Jim. This question's from Jay. Jay said he quitted the rental market, and so for 60-day notice for that has been expired. Could he still go to the court now or wait till September 30th?
Yeah, this is great. I love these questions because I give you so much information that it's hard to absorb in real time, and it's in one of my slides. This constitutes one of the no-fault eviction processes, and under AB 832, the courts will allow you to go in on October 1st, but not any earlier than that for that eviction process to start. So that would mean that you'd file it on that day, and maybe you get a trial in late November if there's no default taken, a trial in November or December, and fight about it.
I see. So like with such a horrendous amount of tenants not paying rent, so what's the chance to get in line for having a case to be addressed in the court after October? Do you think it's going to be a very, very long wait?
Yes, it's going to be a zoo. The courts are under-resourced, understaffed. They've taken the short end of the stick in terms of funding. We have in Alameda County, where I practice in both Santa Clara County and Alameda County. I've got a case right now in San Mateo County. There's differing levels of efficiency, but Alameda County and Santa Clara County are horrendously slow already. The system will not be allowed to absorb all of the small claims actions, all of the unlawful detainer actions. I can only imagine that the courts may send out, an APB, an all points bulletin, for people to mediate and assist in trying to work out of court settlements, and and avoid trials. But tenants in Alameda County, there's an organization that's funded by charitable funds that provides services for free to tenants, so they don't have to pay the attorneys. But they are notorious, even before the pandemic, of taking everything to trial, because the further they extend the process, the more leverage they have in getting a better and better deal. And you could be tied up in trial for 5 to 7, 3 to 5 days. And they have a right to a jury trial. So you can imagine the enormous costs and burdens that are placed on landlords to not only allow tenants to remain in place, but to forgive past rent, to have a lot of cash for keys, inducements, so that the landlords will lose more money rather than get it back. And they're going to have to be expected to delay their right to possession. Now, if they want to say, I'm going to demand I'm going to, on a matter of principle and a matter of that I'm right, I'm going to demand a jury trial, I'm going to win. Assuming even you do win, if it's a COVID-19 tenant, you're not going to get more than 25% of your rent through that process. And so you're going to have a separate process to collect the other 75%. You're going to have to show that you made every effort to try to collect governmental assistance. There's going to be a lot of things that are going to be between you and getting a judgment, even for a right of possession. And then the sheriffs are going to be backed up, because if the tenant doesn't leave, the next step is you get what's called a writ of possession issued by the judge. Then you send it to the local county sheriff. The sheriff is going to have a stack higher and higher and higher of executing on these writs of possession. So there's going to be a lot of backlogs. The one thing that may, again, likely happen is when I mentioned to Jay earlier that he can't go into court until October 1st under AB 832, and then not until November 1st for trying to collect rent for non-payment of rent issues. That if the legislature extends the moratorium again to, January or February 1st, those dates are going to be postponed until sometime in 2022. So yes, there's going to be a backlog when it opens up, but my concern is that it's going to be a backlog that's deferred for another couple of more months.
Wow. Yeah, that's going to be really like a zoo, like you said.
Yeah.
So this question is from Song. She said the tenants were not able to pay rent for a period of 4 months, then pay rent after those months. So can she use the rent as current rent and then apply for the government rental assistance program for those 4 months that have not been paid?
If there's still tenant, and this is the important thing, and I could be, you got to test this, but I've seen and I believe that rental assistance is only available for current tenants. So if you have a tenant that left for whatever reason is behind on rent, that rental assistance is not available. But assuming in this question, for this questioner and everybody else, that you have this scenario where there's still a tenant, absolutely. And that's actually a good case scenario, because if the tenant is now catching up on rent, they presumably, if they were a COVID-19 tenant, there's nothing that prevents them from paying more than 25% of the rent. You're already ahead of the game. And any dollars that you get in financial assistance thereafter is really newfound money, and you're getting a cash flow again. So that's a good situation. You're not under the stress, nor is the tenant under the stress of immediate payment in order to avoid an eviction. That's a very good situation. In an array of bad situations where everything's being disrupted because of the pandemic, that's a better situation than most landlords and tenants face right now. Gotcha.
So I have a question from Lauren. So basically he wants to know if there's any update on the governor's promise on rental assistance program to pay full non-payment rent amount. And is there any time frame, and who would be eligible to receive those funds directly from the state?
The simple answer is I don't know. The second answer is sometimes what we do as attorneys is when we don't know the answer, we try to find out how to find out the right answer. And so the way to find out what's available is to go to the Housing is Key website that I gave you on slide 14. with that website. So whatever the promise is or promise isn't, it's going to be funded through the Housing is Key website. And so just apply. The answer is apply and see what's there. Okay. And you have to apply. If you got a tenant that's under financial distress, go ahead and do it.
Mm-hmm. So regarding the small claim part, is that landlord may be able to file their outstanding, the tenant's unpaid rent at 75% at the small claim court, and then the upper limit can go as high as like 25, 30,000. So basically, the actual landlord would have to engage either themselves or hire a lawyer to do that, right? Or and
no,
also like say,
let me disaggregate that a little bit. There is no upper limit in small claims
no
for
upper limit.
Past rent. The $5,000 limit per person has been blown up for rent. So they've created a subclass of small claims landlords that can collect whatever or claim whatever. The second thing about small claims is that you cannot have an attorney represent you. It's forbidden. Now, an attorney can shadow the landlord or the tenant and prepare them for the hearing or prepare the forms, but they cannot appear and represent the small claim landlord or tenant in court. There is an exception. If the tenant loses, the tenant has a right to appeal. And if the tenant appeals, then you have what's called a de novo hearing all over again in front of the judge that's set up for the appeals. And in that de novo hearing, the attorneys can represent, the parties can be represented by counsel.
I see. So that's actually like a formal procedure that the landlord have to pursue in order to file the claim through the small claim court.
Yeah, and the other thing that's just kind of like hanging out there that is never discussed in this legislation and all of these nice categories, and I remember I've been practicing law enough that I remember where I'd represented a bank on a HELOC that had been unpaid, and there was all of these foreclosures and short sales, and it was a lot of displacement in the rental market too. People file bankruptcy all the time. So I would expect that if you're going to small claims, you're going to have a tenant that files bankruptcy and probably discharges that debt too. So a lot of the claims that may mount up may get stayed and never recovered by a spate of bankruptcy filings. It's unsecured, it's a consumer debt, assuming that the tenant really was unable to pay and they're not faking it, and their liabilities exceed their assets, and their major liability is car payments and now rental debt that is mounted for months during the pandemic. Likely they can go into court and get a bankruptcy court to discharge that or eliminate that liability. It's different, however, for if you're in court trying to recover possession, your process is stayed automatically by the filing of the bankruptcy, but you can go to court, and that may take 45 days or so to get a relief from stay from the bankruptcy judge, so you can at least pursue recovering possession of the property. But as far as all the back rent is concerned, you may see, again, sadly, be prepared for bankruptcy filings. So when we get to that point, we're all thinking in the moment, we're all thinking, oh, what happens on September 30th? Can I get to September 30th? And then can I get to November 1st to file the small claims action? If in fact, and again, I think it's a 70-30 chance it's going to get extended. You may invite me, hopefully again sometime in October, and I can have egg on my face, and we're just talking about what the world is like after September 30th, because the legislature did not extend the moratorium. I'll admit that I was wrong, but even assuming that I'm wrong and these laws are going to kick in and the moratoriums are lifted, we're going to be having a new set of problems at that point, where I would think that, I would hope that landlords would think that half a loaf is better than no loaf at all, or even a third of a loaf is better than no loaf at all. And truly try to work with the tenants on trying to get a repayment plan that is manageable over time.
Yes, yes, it's been very, very helpful. Yeah, we really, again, would like to thank you for all the professional advice and information, even though it's not a legal advice. And we encourage any of our attendees who have questions, try to make a one-on-one meeting with David. And in the slide deck that we're going to circulate, that would include the contact information of David. But this is very informative. I really appreciate the time. And what we're going to do, we're going to upload this presentation on YouTube as well, and we'll circulate to all the people within our group so that they have a chance to be educated, because like pandemic time is very special, and for many of us who are either landlord or investors, that it's very important to get equipped, because we don't know how long it will last. But hopefully, by October, when we talk again, if the moratorium is over, then you might have some better news and more positive information.
Yeah, I like to have some humor in this, but this is a very sad time. I know there are no funny punchlines that I can come up with here.
Yeah, it's been challenging, but say, because of you and also your commitment for the community to bring us these messages, it's definitely helped us as investors and landlords, because it's very difficult to find information and make sense, without digesting and spending the time to really go through all of them. So your help for the community is definitely very highly appreciated.
Thank you very much.
Yes. Yeah, thank you again so much. So again, thank you everybody for attending the event, and we would be working on getting the recording out to you, and please feel free to circulate to your friends whom you think that will find this helpful. Again, have a very good rest of the weekend, David, and
You
to
too,
everybody
and
as well.
thank you for this opportunity.